and welcome. You watching a special coverage of the landmark verdict from the Supreme Court today, one that struck down the controversial National Judicial Appointments Commission, which is the 99th Amendment to the Indian Constitution, calling it unconstitutional and void. This would have given the executive a say in the appointment of judges. The Parliament unanimously backed the proposal, but parts of the Indian legal system looked at it as a compromise to the independence of the judiciary. A 5-member bench of the Supreme Court today held the act as unconstitutional and did say that the collegium system of appointing judges is here to stay, even though they did admit it is flawed and it needs fine-tuning. What are the implications of this verdict? Is this the end of the debate, or will we actually see executive take a step back only to fire a fresh salvo? Will we actually see a pitched battle coming in from the Parliament? Is this the standoff between the biggest pillars of Indian democracy, that's the executive and the judiciary, and is this going to go on a collision course? To discuss all of that, I have some of the finest legal eagles in the country, KTS Tulsi, CS Sundaram, and of course Jethmalani joining us all right here on this very special edition. Thanks, gentlemen, for being with us. It's a pleasure talking to you this evening. Mr. Sundaram, if I may start with you, it's a strike down by the Supreme Court. How do you read this decision? The fact that NJAC has been scrapped by the Apex Court, has it undone what the Constitution wanted to do, which was perhaps to restore the balance of powers between the wings of the government? Or do you believe there was going to be political interference in the appointment of judges, and the Supreme Court has only guarded against that?
Look, the facts really speak for themselves. There has, over a period of time, been growing criticism of the collegium system. There was definitely a need felt that the collegium system has to be tweaked a bit and has to be improved. The system of appointment of judges has to be more transparent. This has been a growing mood. But I do believe that the government's own reaction to this was really to capitalize on this growing dissatisfaction and create a balance of powers which was completely government tilted. And I do not think this could be really considered to be wholly constitutional, which is exactly what the Supreme Court in its judgment has done. It struck down what is completely unconstitutional, in that the severance of the judiciary from the executive, the balance of powers, the interplay between the two, all these will get lost completely if the executive is given an upper hand in the appointment of the judiciary. And I do believe that the NJAC Act itself and the constitutional amendment to a certain extent did point towards this direction. The constitutional amendment, of course, was because there was a bit of vagueness in it, and bringing in eminent persons without really who is an eminent person, what is their familiarity with the law, etc. And therefore, that was something which was injecting into the Constitution something which was never considered before, that people who are neither of the executive nor people who are familiar with legal practices, with the judiciary, everything else, could really be eminent in some other line altogether. And would they be the proper persons to be included here? That seems to be the reason for striking down the amendment as far as my understanding at first blush is concerned. But the NJAC itself, the Act itself, really pointed towards a tilt whereby the independence of the judiciary would be greatly blunted. And I think that has been struck down as really not being in keeping with the constitutional intentions. But at the same time, I don't really believe that striking down of the NJAC Act and the amendment is a vindication of the collegium system, because the criticisms which existed for the collegium system still continue. The only thing that the collegium system really did was to keep the judiciary completely independent of the executive and completely separate from the executive. But whether such independence should be done in the manner that it has been done through the collegium system, through a certain opaqueness which you do find, through a system where it is felt that it is very inbreeding, as in judges appointing judges without any kind of external view or vision into this, these are questions which still persist. And I do not think that the judgment is a vindication of the collegium system so much as a striking down and a criticism of what is sought to be brought in to replace it.
Fair point indeed. I've got another very special guest, Mr. Harish Salve, who's going to be joining us right here on ET now, and we'll be talking to him just in a moment from now. But Mr. Tulsi, how do you read this? Do you believe this is a body blow as far as the executive is concerned?
It's a body blow to an attempt to remove the constitutional imbalance. You see, the Constitution as originally framed required the President to make the appointment of judges on the advice of the government, but in consultation with the Chief Justice and the other judges. Now, in the previous two cases, when this procedure came up for criticism, these judges read consultation in the Constitution to mean concurrence. So actually the judiciary substituted the word concurrence and redrafted the Constitution, constitutional provision. Now it is after 25 years that the Parliament made an endeavour to restore the constitutional balance as it originally stood. But it is disappointing that in the name of independence of judiciary, this the power to appoint judges has virtually been taken over by the judiciary itself. There is no other country in the world where the judges nominate their successors. They can perhaps in some cases be part of the appointment process, recommendation process, but to be solely responsible for selection of their successors, there is no other equal in the world.
Right, no other equivalent about it, but let's take it across to Jethmalani, who is a big opponent of the NJAC, and he rather tweeted saying people of India should be greeting judges who've decided on that. But Mr. Jethmalani, the moot question remains, the will of the people is reflected by elected representatives, and 100% support came in from both houses of parliament. 20 state legislatures had actually supported the NJAC. Should the Supreme Court not have given in then?
I am sorry, Parliament is not under the Constitution of India, the sovereign interpreter of the sovereign of people of India. It is ultimately the Constitution which will decide. The Constitution is not amendable at the will of every Prime Minister who comes or every Finance Minister who comes in power.
So the Parliament is not under the Constitution of India, is the word coming in from Mr. Jethmalani. But Mr. Sundaram, if I may come back to you, we all agree that yes, the executive should not be making political interference in the appointment of judges. But how do you open the system? Like Mr. Tulsi was pointing out there, and like you yourself said, there is a lot of opacity. There is a lot of opaque way these appointments really happen. How do you open the system? How do you make it less opaque? How do you get more people in?
This is exactly what we really have to look at. The collegium system itself is a system where you have the collegium of 5 senior judges who are the final decision makers. I mean, they're the first, second and final decision makers in any appointment. Now, to an extent, that has been felt to be a complete supremacy in that there are 5 senior judges of the Supreme Court who really decide who will now come to the higher judiciary, higher echelons of the judiciary. And that is felt to also concentrate the entire power too closely, too much, and within the hands of 5 people whose reasoning process, thought process, whose decision-making process is certainly not open to any scrutiny or any observation also. So therefore, this is a system which really has to be looked at and tweaked a bit. But the way to improve that system is not to replace it with something which really shifts it to the executive in many ways having a final say in that in being able to veto who can be elevated to a judgeship and who cannot, because that is really throwing the baby out with the bathwater.
And one wouldn't want that to happen. But Mr. Tulsi, let me bring this to you. From 1993 onwards, we've had a collegium system. Justice J.S. Verma, who was one of the shining legal luminaries of this country, did ask for a serious rethink, because between 1950 to 1993, some really good judges did make their way, despite the executive having a say in all of that. Is this an argument between the independence of the judiciary on one hand or inclusion of people on the other? And why do you believe the existing collegium, even with the Supreme Court's own admission, needs fine-tuning? It needs a rethink. Justice J.S. Verma spoke about that today, and the Supreme Court seems to be echoing that view without willing to give in on the collegium system.
It needs a rethink because firstly, the entire procedure is not in accord with the constitutional scheme. And secondly, this is completely opaque. And thirdly, there is no wider consultation. It is a closed-door procedure. Neither the bar is consulted, nor the bar council is consulted, nor the government should have any say. So it is an absolute power in any one individual or organization is not a good thing. Supreme Court itself has prescribed transparency as the panacea for all ills. Transparency means that people should get to know what are the proposals. There should be a procedure by which they can air those objections, and there should be some organization which will decide those objections, like the Judicial Committee of the Senate in the United States. But here we have closed door procedure completely, and we are not willing to change. We have to change with times. If the judiciary says that transparency is the best thing for every other public functionary and public authority and the mode of appointment of those authorities, why is it not a good thing for the judiciary itself? So I really think that this was one attempt at wider consultation made, and which was a mild attempt according to me, because all that it did was that the law minister will be part of the commission, of the appointments commission, and apart from that there will be 2 jurists. Now what is the problem with the jurists? Vague. What is vague about being a jurist? I don't think in fact any more precision is required, because there are countries where the common man decides who the judges will be. Why can't common men be trusted? Why should, in Scotland there is a 24-member commission for appointment of judges, and not one of the judges is on that commission. Not one lawyer is on that commission. When the proposal was made that there should be a few judges also in that, it was shot down in the election. The proposition was not accepted. They say that we are the consumers of justice, we will decide whom we want, what kind of judges we need. So I really think that this is a regressive, undemocratic step. This should really be, there should be further debate on this.
All right, your point taken, Mr. Tulsi, but the fact that the collegium system will continue for now, despite all that the Supreme Court has said, and despite the points that you have made, I mean, what is the big deal about eminent judges? And it was just going to actually accommodate many more people from the SC/ST community, the OBC community, the minorities, or even a woman. I mean, that is exactly what the NJAC had proposed to do, that 1 out of the 2 eminent persons should belong to this community. Having said all of that, your point very well noted. Because the collegium system is now going to continue and the Supreme Court has asked for fine-tuning, admitting that the flaws exist, what do you think can be done right now to that existing system? It has asked for suggestions. If I were to ask you, what sort of fine-tuning does it need?
Of course it is. They realize, and in any case, whether they're in admission or not, it is good, it is a positive sign that they are willing to adapt some of the good governance practices. After all, the judiciary gets the flack for all the delay that takes place in the dispensation of justice. More than half the time is spent on public interest litigation, and people who are sitting in jails, people who are waiting for their promotions, they all those become infructuous. They run out their sentence. They serve the sentence even before it is decided who is guilty and who is innocent. So there should be some way of also judging the judges, and there should be some judicial accountability which should also be provided. In the name of independence of judiciary, no institution can become completely immune to accountability.
All right, fair point indeed. Mr. Jethmalani, I'm going to come to you because you are a believer that the existing collegium system should continue. The fact that the Supreme Court itself says it's flawed, and the fact that Mr. Tulsi said that it needs suggestions, it needs to be fine-tuned, it needs to have more say by the government, which is really the elected representatives of the people, what could be done to remove some of the existing flaws?
Well, everything can be improved in life. Everything human can be improved. And I believe that even our system of appointment of judges may need some improvement here and there. But this bill was not intended to make those improvements, and that is why it has been declared unconstitutional. The Supreme Court itself is now considering what improvements to make, and they will hear the bar, they will hear everybody concerned, and let us see what are the problems which the judiciary itself discloses to us about the functioning of the judiciary. Once we know about it, we will help to resolve that problem, but we will not allow the primacy of the judiciary in matter of judicial appointments to be diluted or to be interfered with.
But Mr. Jethmalani, do you think inviting suggestions to improve the collegium system is indeed going to help going forward?
Well, let us see. Anything human is capable of improvement. And if somebody is trying to improve things, the judges are not sitting in a dictatorial chair and going to make some amendments. No, they have called for assistance in this matter. They will consult public opinion. They will consider enlightened opinion. The people who are experts and properly educated in this line of thought, in this kind of education, and they will decide what to do. And when they take up this cause, we will see what assistance to give them.
You know, we need to move forward with this story, and before I do that, I want the graphics to come back on the screen, and we need to explain to our viewers what has really happened today, because this really is a landmark day as far as India's judicial system is concerned, and the war path between the judiciary and the executive is concerned. So what has really happened today is it's a huge snub that is coming from the government, from the Supreme Court, which has decided to scrap the NJAC as was being proposed by the government, because the 99th Amendment to the Constitution of India did provide for this provision. It said it's unconstitutional and void. It then went on to say that the existing collegium will continue. In this existing system, the judges appoint the judges. So in some sense, the judiciary appoints its own successors. It's a system which is absolutely close to anyone outside of the judiciary, and which is the difference that the government wanted to make. So what was the government proposing? The government was proposing that under the NJC, it wanted new people to have come into the appointment, and the appointment committee would have consisted of the Chief Justice of India, two judges, two of the senior most judges of the Supreme Court, and that would have perhaps opened up the system. That was really the view within the government. It would have got two eminent people to the panel as well, including, of course, the law minister. The two eminent people would have got a period of 3 years nomination without a provision for renomination. The bone of contention was the inclusion of these two eminent people, because who are these eminent people? Will they be jurists? Their appointment was largely political, and which is what was the big bone of contention between the executive and the judiciary. They would have been appointed really by the Prime Minister, the Leader of the Opposition, and the Chief Justice, and which is where the big difference was. So before I carry on the debate forward, we just need to look back and see what is it that the court has asked the government to do today. They've snubbed the government. NJC is not going to go through. But the existing collegium will continue. Mr. Sundaram, if I may quickly take that question before I look forward of what can the government do next. The fine-tuning of the collegium is all very good, but why should the executive have no role at all? It should not be overarching indeed. Given they are elected representatives, the question really is, how do you fine-tune this collegium? Because the court has just said they asked for suggestions. This needs fine-tuning, but it's after all the will of about almost all of India, 100% parliament support, 20 state legislatures. How you still go ahead with something that is not really the will of the people here?
You see, we are in a very unique situation here. When you really look at it, there is no other country in the world, whether it's the United Kingdom, United States. I'm really going into the democratic countries. There is no other country in the world where the judiciary appoints itself, where it's a system of the senior judges of the judiciary deciding who will be included into the judiciary, higher echelons of the judiciary. There is no other country in the world which has this. And the reason for this is each country has its own checks and balances in its own way. Now, if you were to take the United States of America, it's an executive decision who to nominate to the Supreme Court. But after that, there are Senate hearings where there's a Senate confirmation. Now, people have faith in that Senate confirmation for the simple reason that people believe that each member of that Senate, despite his own political affiliations, will exercise his mind independently. There is no question of a whip that all the Democrats shall say yes if it's a Democratic president who has nominated a judge. There is no such whip in such cases. It's open to a number of Democrats to actually go against the nomination. So there is a belief also amongst the people that the Senate, members of the Senate will exercise an independent mind in deciding. Unfortunately, that is not the same belief here, because the belief here is that if the government is to make a suggestion, and even if it goes for confirmation before Parliament, then all members of that party will support their government decision, which really means at the end of the day, It is the sole decision of the executive. Now, that is certainly not something we can adopt in this country. So we need a great hybrid in this country, which we have to evolve. One way, of course, is to start off by thinking of means in which to make the entire selection process by the collegium more transparent, more objective, based on very objective guidelines, on very objective factors, and say judges will be appointed on certain basic factors which shall be considered, and not an issue of a mere feeling that, look, by seniority a judge shall be appointed or otherwise. Having said all that, we've got to understand one other thing, that whatever the criticisms given to the collegium system have been, the quality of judges, the kind of judges which we have in the courts today, a very bold, independent judiciary, is a great byproduct of this collegium system. Don't ever forget that however much we may say that the Supreme Court of India has had great judges, which is an absolute fact, don't forget that there was a time when the Supreme Court of India allowed an emergency in India. There was a time when the Supreme Court of India actually allowed an abrogation of the fundamental rights. Whereas today you find a Supreme Court, which is a strong court, which is a court who will call a spade, and if the government does something wrong, howsoever powerful the government is willing to call the government to task if they have behaved unconstitutionally or illegally. Now, this is a great benefit of the collegium system which has come up.
Fair point indeed. I need to take the story forward, and Mr. Jethmalani, if I may begin with you, how do you see this pan out? Do you believe the government will take this lying down, or will it follow with a review? Do you expect Parliament to strike back? How do you see the story unfold over the next few days?
Well, this requires an assessment of the government's character. I have not made a final assessment, though I think that very likely they will try to interfere with this judgment. They will not learn a lesson from it at all, which they should. And already today there is all India rejoicing about the kind of judgment that the Supreme Court has delivered. And if the government doesn't believe in democracy, and the government still wishes to do something to sustain a lost cause, it is their misfortune. I have always said that the persons who are responsible are those who are advising the Prime Minister, because the Prime Minister has a great defense. His great defense is that he is a constitutional ignoramus. He knows nothing about the Constitution. And his second defense is that he doesn't think that the Constitution is a matter of great importance to the kind of work that he is doing. I mean, he is all the time spending his time outside India. What he achieves, he alone knows. No, nothing is happening for the country or in the interest of the country. He doesn't even report what he attains there and what he does. So, if that is his view, well, he is entitled to it. But I think he should have the intelligence to realize that his reputation is going very fast. It is going downwards. And this judgment is not going to add to his reputation, but will destroy it if he doesn't heed it properly. I think he should turn around and now cooperate with the judgment and give up the ambitions of controlling the judiciary as he is controlling some members of his cabinet.
All right, I'm not going to get into the bashing of the Prime Minister right here, because I do expect some kind of a reaction coming in from the government. What do they do next? One will have to wait and watch. But Mr. Tulsi, do you expect the Parliament to strike back in unanimity, considering this really has the entire political class backing the NJAC? I mean, do you expect the Parliament to modify its earlier legislation? Do you expect it to pass a resolution against this order of today? What do you expect the Indian Parliament to do as it strikes back?
I don't know. You see, Parliament is not the same homogeneous body as it was a year ago. When both houses adopted this legislation unanimously, this was also unprecedented, that such a vital legislation was adopted unanimously in both houses and ratified by 16 states. So I don't know whether the same kind of homogeneity will prevail in the present atmosphere, which has got so vitiated. But it is really for the government to think what are their options. I'm not in a position to say anything on that.
Mr. Jethmalani, do you believe we've gone back to a period and a time when the executive and the judiciary are at collision course, at complete loggerheads?
They are not at loggerheads, but if somebody wants to get into loggerheads, it is their, it will be their fault and their ruin.
All right, Mr. Sundaram, I'm going to completely run out of time here, so we'll let you have the last word on this show. Has the Supreme Court today ensured the independence of the judiciary or ignored the will of the people? Those are the two sides of the debate. I want you to pick up one of those.
I believe that they have actually stood up very, very, very strongly for the independence of the judiciary. I do not believe that ignoring the will of the people was a factor here. They did, of course, notice that this is what Parliament wanted. But what Parliament wants has to be in keeping with the Constitution of India. And if what Parliament or the people of India, even a majority for a given period of time, want something which is not in keeping with the Constitution of India, well, the job of the Supreme Court is to see that that cannot go through. So I believe what the Supreme Court has really done today is to uphold the independence of the judiciary.
All right, that's the words coming in from some of India's finest legal eagles, as I've been calling them. Thanks very much, each one of you, for being with us. It's still an open debate, the NJAC being struck down by the Supreme Court. It has its reasons to do so in their fair wisdom. The judges do believe, and a 5-judge bench had actually struck this down, has gone ahead with holding the collegium for now. It's very important to realize here that the will of the people was reflected by the Parliament. The will of the people wanted NJAC to go through. So in some sense, the collegium system is flawed according to the Supreme Court's own admission, and it needs to be fine-tuned and open up even more. Was NJAC a step towards that, or was it a step towards getting political interference in appointment of judges? We'll have to wait and watch how the government plans its next strategy and how the Parliament plans to make it a pitched battle. Thanks very much for being with us on this very special show. It's been a pleasure being with you.
Find us on Facebook at facebook.com/ETNow, and don't forget to click the like button. You can also follow us on Twitter at ETNowLive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/ETNow.